In May 2026, the European Parliament concluded a marathon of overnight negotiations that had nearly collapsed entirely just days before. These talks resulted in an abrupt policy shift, a 16-month delay for the EU AI Act's most stringent regulations. High-risk obligations covering biometrics, employment, and critical infrastructure will now apply in December 2027 rather than August 2026. The European Commission provided a formal technical justification for the 16-month extension. The Commission stated that harmonized standards, critical compliance tools, and the required infrastructure were not ready in time. This administrative shortfall is a documented fact. However, this lack of infrastructure exists alongside a deeper mismatch between the law and the technology. The legislative process was simply outpaced by the technology it sought to regulate. The EU AI Act was conceived and drafted during a specific window in the evolution of artificial intelligence. During that period, large language models operated in a strictly contained loop. A user submitted a prompt, the model generated a response, and a human reviewed it. By 2026, autonomous, multimodal reasoning systems moved from research concepts to production realities. The enterprise market shifted entirely away from discrete, isolated tools, giving rise to massive, continuous, interconnected AI workflows. The law does not yet know the names of the systems that are now driving the enterprise. The European Union built a regulatory framework for a world that has already passed. Applying static regulations is impossible when the operational boundaries of a system can no longer be drawn. To understand how regulators viewed the technology, consider the architecture of a standard 2023-era large language model. This setup was highly legible. It functioned like a traditional software tool, relying on a human bottleneck before any action could be executed. Because the system operated linearly, regulators could easily determine who was responsible for the final output. This legibility forms the foundation of the EU AI Act's Annex 3, the legal architecture used to classify high-risk applications. Annex 3 flags specific high-risk use cases, including recruitment tools, performance evaluation modules, and task allocation algorithms. Regulators enforce this by drawing categorized boundaries around isolated, single-function tools. The entire framework relies on the ability to distinguish between low-risk and high-risk applications based on these isolated functions. If an AI system performs exactly one task, assigning a proportionate legal obligation is straightforward and enforceable. The intellectual rigor of the EU AI Act assumes that AI will remain a bounded system performing an identifiable task. That assumption has been broken by the deployment of Agentic AI. Market projections show the scale of this shift, with the Agentic AI sector growing from $7.8 billion today to over $52 billion by 2030. By the end of 2026, 40% of all enterprise applications are expected to embed these autonomous agents. Agentic AI operates differently. It does not wait for a human prompt to function. These agents actively plan, make autonomous decisions, and execute complex, multi-step workflows. They integrate directly into intricate enterprise environments with minimal to zero human intervention. These systems initiate real-world actions continuously, operating across traditional organizational silos. AI is no longer a discrete software application. It has become an underlying infrastructure layer. By removing the human bottleneck and automating workflows, the concept of a single identifiable decision-maker becomes difficult to locate. Enforcing the EU AI Act requires placing this sprawling agentic infrastructure back into rigid legal categories. An operational collision occurs when a single agentic system performs recruitment, task allocation, and worker monitoring simultaneously. This simultaneous execution makes it impossible to determine which singular regulatory category the AI's action falls into. Executives from ASML, Airbus, SAP, and Mistral AI formed a lobbying coalition in response to this mismatch. Their core warning was that forcing modern AI into obsolete regulatory boxes would regulate Europe out of the global AI race. This sustained pressure on the implementation timeline ultimately succeeded. While the Act's risk-based architecture remains intact on paper, the industry proved the implementation was structurally unready. Attempting to govern dynamic systems with static borders forced this 16-month retreat. For global organizations, these developments present a specific practical trap. The EU AI Act applies to any organization offering AI systems in the EU market, regardless of where they are headquartered. A South African company deploying AI-driven HR tools or credit scoring to European clients falls fully within the Act's scope. South Africa's own draft national AI policy explicitly draws inspiration from the EU's risk-based framework. Executives who misinterpret the 16-month extension as a reason to pause their compliance preparations take on immense corporate risk. The delay provides a longer runway, but it does not erase the underlying legal obligations for any global company touching the European market. Global policymakers and business leaders are currently benchmarking against a document that is in a state of flux. Boards must stop asking if the compliance deadline is 2026 or 2027. They must evaluate whether internal governance was designed for the discrete duels of the past or the autonomous infrastructure of today. The gap between rapid technological capability and rigid legal governance will never close on its own. Survival requires building governance frameworks that are designed to learn and adapt in real time as the technology moves.